Hey, everybody. This is for Chapter 5 for Constitutional Law. And it starts on page, let's see, 119 of the text. I will share this stuff. Share PowerPoint. Okay, so this is the slides for Chapter 5. I'm not completely sure. I'm not completely sure if we would be able to get through all of this information in one class period. It's a lot of information. So we'll do our best. And I honestly won't know until I start going through this. I know it took a long time to put slides together, so we'll go from there and kind of see what happens. So let's see. So we want to talk about the history of the Constitution. I think we kind of gloss over some of this, and I'm sure you've learned about these things in other classes. I can't imagine that this is the first time you've heard about the history of the US Constitution. But it was drafted in 1787. And it's the first time in world history that one document has governed so many people, or that's lasted this long. It's withstood many challenges. And I like to describe it, Foss, you gotta stop, buddy. It's really a living, breathing document. It changes all of the time. It changes with court cases, with legislators, as time goes along. It's a living, breathing thing that isn't set in stone, which is nice. But it does sit above everything else in our legal system. Okay, I'm taking it. Take it outside. Go. Take it out of here. Go. Go, go, go. Out. Go. Okay. My dog is chewing on an animal it's like filled with that loud plastic that crunches that they really like, but I don't know if you can hear it, but it's loud in here with him chewing on it, so he got kicked out. Okay. So if we look at world history, the U.S. was the first country founded based on the idea that people could govern themselves. So prior to the Constitution, the United States had a thing called the Articles of Confederation. So when the Articles were first put together, every state, they were like independent countries, just like the European Union is now. So the problem is they were charging taxes coming into each state. So Kansas could impose a tax on things coming in from Nebraska. Every state was sort of just making their own rules. There was lots of fighting. The federal government wasn't making any money because they had no right to tax, and they had no right to govern over everyone else. So essentially they said, I'm not really sure that this is working out. So several years later, instead of amending the Articles of Confederation, delegates from every state got together at the federal level and they drafted an entirely new document. They came with the idea that federal government should be able to tax and spend at the federal level. They should be able to regulate commerce. I mean, we have a gigantic country, and we can't have 50 different borders within that state. So they wanted to be able to centralize the regulation of commerce and control the borders, whether they be our international borders or borders between states. And they want to be able to do what most national governments do, which they were not doing at the time. So let me move myself. How much power should the people have? I think people have a misconception that the founding fathers thought to themselves, oh, we're all about equality and we want the people to govern everything. And that could not be further from the truth. I don't know if you've paid much attention, but our general population is not full of a lot of super intelligent people that we want to be put in charge of governing anything. And many state leaders didn't want democracy extended to the common person. I think that's why it was really limited. If you look at the original drafting, it was limited to basically rich landowners. Those were the only people they wanted anyone to be able to have any rights under the Constitution. They also feared the mob rule. So it's arguable that we've seen this recently, where it's just majority wins. And often the majority of our country, or the majority of anywhere, might not be a group of people that are necessarily a group of people that we want making the rules for everyone. Mob rule often isn't the best way that things should go. It generally is never. But leaders on both sides, they disagreed, they debated and decided how much and what kinds of powers people should have. Everybody agreed that really concentrated centralized governments that they had in England, for example, was corrupt, and they didn't want that. So the Constitution is a document essentially drafted off of lots of compromise. They did want a separation of powers, which is clear. It's one of the major foundations of the Constitution. They didn't want to concentrate power in any one place. So the intent behind the three branches of government was to avoid what they had seen in their previous government. Bossy. Put it down. Anyway, so separation of powers we've gone over several times. Article 1 under the Constitution governs Congress. Article 2 discusses the presidential powers, and Article 3 is regarding the judicial branch. So this combination of the three articles created what they felt would be the best sort of checks and balances. So there were also individual rights, and the original Constitution really said nothing about individual rights at all. It was silent to them. That's what you say from a legal perspective. It's silent about the issue. So in 1791, so a few years after the Constitution was drafted, the amendments to the Constitution were added in, which were titled the Bill of Rights. So voters elect representatives. This is regarding the congressional power. Voters elect representatives that go to Washington, D.C., to the federal level, and serve in Congress. We have, as I've said many times before, two parts of Congress, which are one, the House of Representatives. It has 435 members, which are elected by population. And the Senate has 100 members, which is 2 from each state. So one is by population and one is just the same across the board. So California has as many senators as Kansas. Article 1 of the Constitution grants Congress the ability to create laws or statutes. Essentially, there are 18 kinds of laws that Congress can create. One of the most important ones that we will be discussing in this class that's really relevant to, of course, business law, is the ability to regulate commerce among the states. This is called the Commerce Clause, and you'll hear that a lot in this chapter. So the Commerce Clause was really the result of all of the issues they had prior to the Constitution, where states were just constantly at odds with each other and creating rules and taxes and tariffs against other states. So there was just chaos prior to the drafting of the Constitution. The Congress wanted to make sure that there was fairness across state lines and stop them all from imposing taxes on each other. And they were also imposing statutes that hurt other states. So almost all statutes that affect business in general are passed under a thing called the interstate commerce. The question, and interstate means across state lines. So one question that is continuously asked, especially in case law, is, are all business transactions necessarily interstate commerce? If I have a business making friendship bracelets that I sell to other people in McPherson, am I affecting interstate commerce? If I am a tomato farmer and I only sell to Dillons in Kansas, am I affecting interstate commerce? these are a lot of questions that arise in court cases. So here is one of the cases that discusses that very issue, which is called the substantial effect rule. Roscoe Filburn, which I have noted here is the best name in American history, was a wheat farmer in Ohio. He grew and sold wheat only in the state. So he wasn't sending wheat anywhere else in the United States. But during the Depression, the grain prices fluctuated all over the place. So the federal government stepped in and tried to regulate how much everyone could grow. And they still do this. Filburn, old Roscoe, claimed that Congress didn't have the power to govern his business because he was not engaging in interstate commerce, which I think he has an understandable argument. But the Supreme Court disagreed with him. They said Congress can regulate any activity that has any kind of substantial economic effect on interstate commerce. Another case is United States versus Lopez, which you can tell by the name of it is a criminal case. But Congress passed the Gun-Free School Zone Act, and Lopez was convicted of violating that statute. In his defense, he argued that Congress had the power to pass laws, but this law did not have anything relating to interstate commerce. And the Supreme Court said, you know what, you're right. The possession of a gun at school has nothing to do with any economic activity. Nothing's being sold, nothing's being affected anywhere. So it didn't have anything to do with interstate commerce. And so that is now unconstitutional. To move myself again. Does the Commerce Clause compel or force people to enter into commerce? In National Federation of Independent Business versus Sebelius, which may sound familiar to you, or maybe not. Sebelius is a former governor of Kansas. In 2010, Congress passed the Affordable Care Act, also referred to as Obamacare, if you have only heard its slang term. But this required people to buy health insurance, or you would have to pay a fine. So 13 states challenged it. People were pretty upset about it. So essentially you had to spend whatever the Affordable Care Act, for example, I'll just give you a real world example. My personal monthly health insurance that I buy off the market is $560 a month. Depending, I think there's a sliding scale for Affordable Care Act where you can get on the government's website and you can buy more affordable insurance based on your income. So if you did not do any of that, if you didn't buy any health insurance, then you were penalized when tax season came around by, I'm gonna have to Google, I don't remember how much it was, but it was painful. It was a significant amount of money, enough where, any reasonable person would have just said, you should have bought health insurance. So the issue under that case was, did Congress have the power to force citizens to purchase health insurance under the Commerce Clause? And the court said the federal government cannot force citizens to buy health insurance. What Congress can do is impose taxes. So maybe the people don't have to buy insurance, but Congress is permitted to impose taxes. So because taxes are covered under one of the things that Congress can enact rules about. So what they said is, no, you can't make people buy health insurance, but you can just call it a tax. So it struck down part of it. And now I believe last year, I could be lying to you guys again about stuff, but I'm pretty sure last year they did away with the penalty for Affordable Care Act. So they still have the Affordable Care plans where you can get sort of a reduced amount, but you don't have a penalty now that's imposed during tax season. State legislative power. The negative side of the Commerce Clause, whoa, go back, is basically the state can enact laws that the Commerce Clause doesn't doesn't touch. So any state statute that discriminates against interstate commerce is always unconstitutional. For example, Michigan and New York, I don't think this is a real life case, but this is just an example to understand the principle of it. Michigan and New York allowed wineries to sell directly to people in their state. So a winery could sell in New York, could sell to citizens inside New York. The same states denied those sales to wineries outside the state. So New Jersey couldn't sell their wine products from wineries to New York citizens. The two states are discriminating against the other states, so their laws are unconstitutional. That's essentially the negative side of the Commerce Clause. There's also the Supremacy Clause. If there's a conflict between federal and state statutes, federal always wins. It's considered the law preempts the field or controls, and the state law becomes void. State law only controls when there is no conflicting federal law, and Congress hasn't intended in some way to dominate that particular issue, which can be confusing. I think that's why there's so many court cases about it, but we have some pretty well-established case law that we cover here in just a minute. Article 2 of the Constitution is regarding executive power, or the president, the executive branch. The president's job is to enforce the laws of the nation. That's the overall essence of what the president of the United States is supposed to do. And 3 of his powers are: 1, to appoint. So the president appoints all of the administrators. So we talked about in the last session about administrative law, and how, there's the head of the EPA, the head of Department of Education, the head of Health and Human Services, everything you can imagine. The president appoints all of those people. So that's why often they say that the president has the most effect, or the president's administration has effect over a lot of administrative law. He also appoints judges, and judges are appointed for life. These are federal court judges, of course. Regarding legislation, the president proposes bills to Congress. Doesn't necessarily draft them himself, but he'll say, what bills that he'd like to see come through, so that he will sign them into law. And then, of course, foreign policy. So the president negotiates treaties. He deals with a lot with international relation and runs the armed forces. It is important to know that the president cannot declare war. Only Senate can declare war. Presidents often do. I'm going to have to see what the term is, but they'll exercise use of the armed services that isn't war. For example, I believe Bill Clinton deployed more US troops in battle zones that were not wars than any other president in US history. I'm going to have to look that up, but I'm pretty sure that's the truth. So they can't declare war, but they can do some sort of, I'll have to look it up. It's called something else, that they'll send troops out to do certain missions under the United States powers. Article 3, judicial power. The federal courts hear 2 kinds of cases: civil and criminal. There's also judicial review, where the federal courts can declare statutes or governmental actions unconstitutional or void. A lot of times people think that this is overreaching on the judiciary. The Constitution doesn't necessarily grant that power. The courts just sort of done it. So the question that a lot of people have are, is judicial review good for the country? Just by a manner of what they do, cases will come before them to determine the interpretation and the constitutionality of certain laws. And so just by the notion of what they do is why they exercise the power that isn't necessarily described in the Constitution. So if we look at a case called Kennedy versus Louisiana, a criminal case, Patrick Kennedy was convicted of raping his 8-year-old stepdaughter. A forensic expert was called to the stand and testified that the girl's injuries were the worst injuries that the forensic expert had ever seen. The jury in this case voted for the death penalty, which was legal in Louisiana at the time under statute. Kennedy, the defendant, appealed, claiming that the statute itself was unconstitutional because under the Eighth Amendment of the Constitution, we have a prohibition against cruel and unusual punishment. And that includes penalties that aren't proportionate to the crime. So the issue under appeal was, did the Louisiana statute, so the statute permitting the death penalty, did that statute violate the Constitution by permitting death penalty for a rape case, essentially for a case that did not involve murder? And is it proper for the Supreme Court to even hear the case? The court says, we really should hesitate to allow a state to extend the use of the death penalty where no one was killed, no life was taken. The crime may be awful, yes, but the crime was not murder. So Louisiana then reintroduced, so the law was struck down. It was considered unconstitutional. So in 1995, a few years after that particular case, Louisiana reintroduced it. And then 5 states did the same. There were southern and Midwestern states like North Carolina, Michigan, Oklahoma. I'm gonna have to remember the other one. And they were, the death penalty was reintroduced for child rape. And then in 1994, year before that, this is likely why Louisiana did it. Congress expanded the number of crimes eligible for the death penalty, but child rape wasn't one of them. So I know treason is one. There are a few where you can impose the death penalty, but child rape hasn't been considered a capital offense in the United States. So the amendments protect the people from the power of the state and federal government. These are called protected rights. The people are the citizens of the United States and corporations. So legally created corporations in the United States are considered individual people. So we also extend those rights to people, citizens of other countries who live in the United States. And your constitutional rights protect only against acts of the government. So, and I don't know how many times I've had to explain this to people over the last couple of years. You'll see a person on Facebook or Twitter or something yelling about censorship and First Amendment rights because something was deleted or their accounts were frozen or whatever. You have zero right to free speech on private forums. And that's what platforms that are owned by private companies, so all of the social media that you use are private companies. If the US government went into one of the social media platforms and started shutting down individual accounts because they disagreed with the speech of certain people, that is protected free speech, but that's not what's happening. It's just people are saying idiotic things that violate the rules and regulations for the individual company to use their platform. You can stand in your front yard and act like an idiot and say whatever you want. You can't necessarily get on the internet and have it blasted to the whole world. So free speech in the First Amendment says Congress shall make no law abridging the freedom of speech. The founders believed that democracy is only going to work if we can hear each other's point of view, if we can talk, argue, etc. Speech also includes symbolic content, so not necessarily your words. In Texas versus Johnson, 1989, Mr. Johnson burns a flag outside of the Republican National Convention and was arrested under a statute in Texas. Yes, obviously it's Texas versus Johnson. In Texas, under a desecrating the flag statute. He appealed, and the issue was, does the First Amendment protect flag burning? The court said yes. So you can go out and burn all the flags that you want. People might not like you, but it is part of your protected speech. There is political speech. It's protected unless it's intended to create imminent lawless action. We've seen examples of that fairly recently with where such questions have been played out in front of us live. It's arguable whether the Capitol insurrection incident was political speech, which is protected until it created lawless action. So when people say you have free speech, that doesn't mean you can just say whatever you want whenever you want. If you're going to cause danger of any kind or scream fire in a movie theater, things like that, that's not protected speech. There's no protection for you to say those things. There's a time, place, and manner exception where free speech is protected, but the government can regulate when you can practice your free speech, the place that you do so, and the manner that that speech is provided. So they can require you to have a permit to do a march. They can only allow you to exercise your free speech in a certain area of town or between the hours of 1 and 4 on certain days of the week. And then there's also the question of morality and obscenity, which was brought to light in Miller versus California. So the question that the court had under morality and obscenity, which is not necessarily protected under the First Amendment, if it's morally reprehensible and obscene, it's not protected speech. The question is, what's morally reprehensible and what's obscene? It wasn't really identified. So the question in Miller versus California was, would the average person find that it has prurient interest? Which that's a question in itself. Is the work patently offensive? And does the work lack literacy, artistic, political, or scientific value? These are all incredible matters of opinion. So there's lots of confusion about obscenity and morality in speech. There's also commercial speech. The government can regulate commercial speech provided that the rules are reasonable and they have to be tied to a goal. So if you remember back to our cigarettes case last week, the goal was to protect people from at some point, but it wasn't reasonable, nor was it constitutional to force the cigarette company to state things on their packaging that they did not necessarily believe in, which were, the dead bodies all over the packages. I believe that this is pronounced Salib, so that's what I'm going to say. Salib versus the city of Mesa. Salib owned a donut shop and he put a gigantic sign in the front of his window to advertise it. And the city gave him a citation claiming that he violated local code. Salib sued, claiming the city violated his First Amendment rights. He thinks he should be able to advertise anywhere he wants. The trial court sided with the city, and Salib appealed. The issue on appeal was, did Mesa, the city of Mesa's sign ordinance, did it violate the First Amendment? So were they violating Mr. Salib's First Amendment rights? They put a 3-pronged test together to decide if his rights were violated. So the first prong is the government has to assert a substantial interest in support of the law. In this case, the government, their interest was in protecting the aesthetics of their city. They didn't want to have an ugly looking city with donut signs in all the windows or whatever the businesses were. The government has to then demonstrate that the challenge law advances its own interests in a direct and material way. And then also the law must be very narrowly tailored. So for the rules for City of Mesa, they said that you couldn't cover more than a certain percentage of your front windows with advertising. I think in the neighborhood of 30%. So no more than 30% of your window could be covered in advertising. And Salib's, it covered most of the window. I think that's why he received the citation. So Mesa won this lawsuit because the court said the law was narrowly tailored. So it didn't apply to everyone for all reasons. It applied only to business owners and only because we don't want them to cover certain portions of the front windows of businesses in town because it looks bad. So it supported their personal interest. It was narrowly tailored to just businesses for a specific reason. And they didn't say you couldn't do it at all. They just set it at a percentage for a specific reason. The Fifth Amendment. Obviously, now we're not going to go through every one of them, but we are covering a few. The Fifth Amendment, let's give an example of this. You are a senior in college. Your professor claims that you cheated on a final exam and gives you an F. You say that you're innocent and you want to know the allegations against you. And they tell you that you can have the allegations heard at a school hearing. But if you lose the hearing, you're going to be expelled and your transcripts are going to be marked for cheating. So the hearing at the school is led by a junior faculty member who does not have tenure, but their tenure next year will be decided by the professor who is accusing you of cheating. So both professors examine the final, and each of them decides that you did in fact cheat on the final. And then you are expelled. The question here is, were you treated fairly? I think most people would say in this instance, probably not. I think students would think likely not. But under the Fifth Amendment, no person shall be deprived of life, liberty, or property without due process of law, nor shall private property be taken for public use without just compensation. So the Fifth Amendment is about due process. There is something called procedural due process. So before the government can take anything from you, including your liberty, like your freedom, or your property, your home, the affected person has a chance to oppose it. So you can challenge them, you can hear the allegations, you can be heard. Is the government attempting to take liberty or property? And if so, how much process do they owe you? So it's not all the same for every reason. So what is a liberty or property interest? Confining someone to a mental institution and taking their kids away. That's a liberty interest. A court forces a person to sell their home to satisfy a lawsuit. That is a property interest. So one, they're taking away your personal liberties. I'm not sure that there's another way to put that. Your personal liberties being your freedom, your right to move about, your children, your family. And then there are things that you own, which are the property interest. And they can also be subtle things. So you can have a property interest in a job. So is firing someone something that requires due process? Well, maybe for some people it is. Maybe for certain kinds of jobs it is, and maybe in certain areas. Is an education a property interest of a student? Does she deserve a hearing prior to being expelled? These are the questions of wondering what kind of due process is owed to someone before you take something away from them. So to answer the question of how much due process is due, the more important the thing is, the more formal the hearing should be, which seems logical. The fact finder doesn't necessarily have to be a judge, but the person hearing the matter has to be neutral, that whether it's a court or it's an employment supervisor who's listening to a termination claim. The attachment of property has to have a high level of due process because it harms the property owner. For government employment, government employees must receive due process before being fired. So they're entitled to a hearing run by some kind of employment supervisor, but it's not a court hearing. And then there's academic suspension. This is the least important of the three. So you're going to get notice, and then the opportunity to respond to that notice is enough due process. So you don't get a hearing. You don't even have to have some kind of informal hearing. It's here's your notice, here's what we think occurred, and you can respond to that or not, but that's all of the due process is owed to a student. There is something called the taking clause under the Constitution. So let's say that a husband and wife want to expand their plumbing business on land that they already own. The city said that, yes, you can expand, but only if you give part of that land so that the public can use it as a bike path. The question is, can the city make a person do this? Can they make them? The takings clause under the Constitution prohibits